On March 23, 2025, officers in Texas responded to a reported theft at a Nordstrom rack. That response set off a chain of events that brought defendant Miss Eldridge before a magistrate on a charge of possession of a controlled substance. She stood accused of possessing approximately 9 grams of what the arresting officer identified as, quote, Mexican Xanax, end quote. Her defense counsel appeared via Zoom and immediately raised a critical question. How did the officer determine the origin and legality of that medication? Under Section 481.117 of the Texas Health and Safety Code, a person commits an offense if she knowingly possesses a controlled substance listed in Penalty Group 3, unless that person obtains it under a valid prescription from a practitioner acting in the course of professional practice. Alprazolam, sold under the brand name Xanax, falls squarely within Penalty Group 3. That statutory prescription defense would become the central issue in this proceeding.
Do you mind if I get a PSR on Miss Eldridge here, please? She's in custody. Obviously. All right, good morning, Miss Eldridge. I'm bringing you out because we're talking about you. It's only fair that you hear what's going on.
Yes, sir.
Ma'am, you stand charged with us with possession of a controlled substance. I don't know what's happened in your case. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. I've appointed you a lawyer. Your lawyer is here with you, but he's on Zoom, so that you know you're not here alone. Greg.
Can I talk to my lawyer first?
I'm sorry?
Can I talk to my lawyer first?
I'm okay with that.
Call the
Yeah.
back, Judge.
What number do you want him to call?
You gotta get the other number on that.
3198.
Call 3198, and then as soon as you're done, come back and then we can, I guess, do probable cause at that point.
What are the first numbers? I always forget, Judge.
It's 927-832-927.
Okay, got it.
Not yet.
Should I give it a few minutes? They gotta take her.
I guess I should have chatted.
Oh, and Judge, I did send you a direct message when you get a chance.
Yeah, all right. You know, I'm kind of slow sometimes, you know?
Yeah, it's
I
more
guess
for the
just so you know.
reset, just so you
Let me know
know.
after you're done.
So
Sorry.
you somebody could.
Yeah.
Okay.
I just need him to come up.
Mr. Behart, are you ready? Coming up, we'll have you sign and we'll get you guys out of here.
Christopher Roberts?
First, I'm going to one, required to turn and off.
Over here. I'm sorry.
We need you guys to sign.
Oh.
Yeah.
Hey, Shreya, I think she got a pump.
Yeah. Yeah.
Confirming it now, but I want to say they got it too.
With Sylvia.
2006. Okay.
I'm confirming it now because I asked Sylvia to confirm for me so that,
Last I talked to Sylvia, she said, yes, she should have it and she goes back.
Okay.
Thank you.
I'm waiting on her to let me know definitively.
Sylvia's the only one that got a test.
She's the only one that gets, she's great.
The only one.
She's amazing. I know. You don't have to,
I was like, Sylvia's losing.
yes, she is.
Patrick Walker, come on up. Yeah. Oh, she's come up here. Yes, come up here.
All right, so, great.
Yes.
So Ms. Eldridge, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 3rd, March 23rd, 2025, at approximately 3:05 p.m., officers responded to a theft at Nordstrom Rack. The officers gave a description of the vehicle involved in the theft, and the officer located the vehicle, which was occupied by a male and female. The officer asked the defendant if she had any property inside the vehicle, and the defendant stated that she had a purse. The officer asked for consent to search the purse, and the defendant granted permission. The officer located a bottle of what they knew to be Mexican Xanax, which was approximately 9 grams. The defendant stated that she had a prescription but was not able to produce it. Based on the circumstances and the defendant's previous drug charges, the officer believed that she did not have a prescription.
Officers located a black 2015 Hyundai matching the vehicle description provided by Nordstrom Rack. Miss Eldridge was a passenger. The officer asked whether she had property inside the vehicle. She identified her purse, and the officer requested consent to search it. Miss Eldridge granted permission. Under the Fourth Amendment, when a person voluntarily consents to a search, police do not need a warrant, and any evidence discovered becomes admissible. This distinction matters because once consent is given, the defendant effectively waives her constitutional protections for that search. Here is where the case becomes legally significant. The officer located a bottle of pills and identified them as Mexican Xanax based on what the prosecution described as previous work experience. Defense counsel challenged this directly, asking the court a pointed question: how does a patrol officer visually determine whether a pill originated in Mexico or was dispensed domestically? Miss Eldridge told her attorney that her prescription came from Scott Reed's pharmacy in Midtown and that the pharmacy should have records confirming it. If true, the entire basis for the charge would dissolve. Defense counsel indicated he would file a motion to inspect evidence, a procedural step that would allow verification of the substance and its origin.
May I respond, Your Honor?
I don't know.
Sorry?
Were they just in the street in a car?
They were inside the vehicle that was identified by them as the vehicle for the theft. So
I guess I missed it. There was a theft.
they were dispatched to Nordstrom for theft.
Okay.
They went to Nordstrom, they were advised that
Those were the people.
to give a description of the vehicle that was involved in theft. They located the vehicle, they were found in the vehicle.
Anyone
Your
else
Honor,
who
if I may,
can find this?
Your Honor.
Shh. Say it again?
Can I say something real quick, Your Honor?
Yeah.
I mean, there's no description of the vehicle. I mean, there's not specific articulable facts here. Just a white vehicle. We saw a white vehicle. We pulled it over. No description of the people in the car.
It was
I'll have her read it for you.
It was a black 2015 Hyundai passenger car bearing Texas license plate KZD 1788.
Okay.
So we do have a description and a
Give a
license
good
plate.
description of the car. Did anyone get arrested for the theft?
It doesn't look like anybody was charged with that. I don't have a could have been in here.
Okay. Ma'am, I'm gonna find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not gonna go well for you. Do you understand? So what should we do about bond, guys?
Well, Judge, so she tells me she does have a prescription. It's from Scott's in Midtown. What I found was Scott Reed's pharmacy. There is one
It's
on.
Mexican, man.
How does the cop know that?
She
Really?
said it's Mexican Xanax.
Yeah. Okay. How does the cop know that?
Huh?
The cop sees a pill and goes, "Oh, this is from Mexico," or "This was in the lab."
It's based on previous work experience, Judge. So
Yeah. Well.
I mean, go see what you can get, I guess, right? And then,
All right. We'll
but
do
I need to set a bond, no bond right now. So I gotta set.
Okay, I'll do a motion inspect evidence when I have time, and we'll go.
Yeah,
But that being said, Your Honor, she has a $10,000 bond on the felony that was set, and there's a chance she might have a script for this, and she says that they actually should have records of the.
What should we do about bond?
I mean, I would ask for, she's got a 10,000. I would see if the court would do a PR bond on this one. If there's she has to make the felony bond, and there's a chance she does have a script for this. She shouldn't even be in custody on this if that's true.
Defense counsel requested a personal recognizance bond, known as a PR bond, which would release Miss Eldridge from custody without requiring upfront payment. However, she faced a compounding problem. She was already on felony probation with an outstanding $10,000 bond she had not posted. The prosecution indicated she had been listed in absconded status by her probation office. Defense counsel offered a possible explanation, telling the court that Miss Eldridge had been switched between probation officers and that a mix-up involving her reported address in San Leon, Texas, may have occurred. The court was not persuaded. The judge expressly found Miss Eldridge to be a flight risk based on her felony probation status and her failure to remain in compliance. Notably, the theft that initiated this entire encounter never resulted in charges against Miss Eldridge, raising legitimate questions about the scope of the investigation that followed.
She was in absconded status as far as the felony is concerned. I think that she's a flight risk.
Well,
So,
and may I say something on that too, Your Honor?
sure.
On the MAJ, so she tells me she was reporting, she got switched probation officers. Again, I don't know the veracity of this. I'm just relaying. And so I'm showing that the address that was last reported, this is what they're claiming MAJ as well, was San Leon, Texas. So I don't know if there was a mix up in that where the probation office was. And I don't know if that may have, so I'm just throwing that out there, that may have been part of it.
What do you think for bond?
Judge, we'd oppose any PR bond. We'd ask for a 630 at any amount at your discretion.
Okay, so what I'll do is I'll set bond at $1,500 surety.
Okay.
Okay, I'm not gonna grant you a PR bond. I think that you're a flight risk and you're on felony probation. Regardless, you've not made the $10,000 bond upstairs. If you're able to make bond, we can come back and talk. But if you do, it's extremely important that you maintain contact with the lawyer here.
Yes, sir.
Because if you don't, another warrant will issue here and it's just gonna balloon and just get out of control. Okay? It looks like you have felony court on the 9th
Yes.
of next month. So what we can do is we can set you on the 10th, the following day, to see what happens there. We can't set you the same day, but we'll set you for the day after, and then we'll figure out how to go forward at that time.
The judge denied the PR bond and set bond at $1,500 cash. The court imposed conditions ordering Miss Eldridge not to consume alcohol, illegal drugs, or unprescribed controlled medication, and subjected her to random testing. Her misdemeanor matter was scheduled for the 10th of the following month.
Oh, I don't know.
I can get on in the morning, Zoom, Your Honor, on the 10th.
Are you sure?
Yeah, it's fine.
Okay, then, okay, so set it for the 10th and he can zoom in at that point for this case. And then, so I'll set bond at $1,500. Okay, man, good luck.
But yeah, she has a friend that might be making bond. She doesn't know yet. So if that plays out, obviously she's going to pop up here before.
Just come back and we can talk.
Okay,
you know?
thank you.
She needs to sign conditions, please.
What stands out in this proceeding is the convergence of unresolved questions. The officer's identification of the pills as Mexican Xanax rested entirely on visual inspection, yet no field test or laboratory confirmation was referenced during the hearing. If Miss Eldridge possesses a valid prescription for alprazolam, her attorney can demonstrate lawful possession and the charge collapses entirely. This case illustrates a principle that extends beyond one defendant's circumstances. The line between lawful possession of a prescribed medication and unlawful possession of a controlled substance can be remarkably narrow, often turning on documentation a person may not carry during a traffic stop. The constitutional protections of the Fourth Amendment and the statutory prescription defense under Section 481(117) exist precisely for these situations, to ensure that individuals are not deprived of liberty on the basis of assumptions rather than evidence. If there is a case or courtroom interaction you would like us to cover, let us know in the comments below. Thank you for watching, and please subscribe and share so we can continue building a more informed and legally literate community.